Prepare for an objective journey into the heart of the legal process. The footage you are about to see remains completely unfiltered and unedited. It is a raw, first-hand account from the front lines of justice, delivered with utmost professionalism and integrity.
License and registration now!
Officer, why am I being stopped? I'm legally parked.
I didn't ask you questions. Hand it over!
Am I being detained or am I free to go?
Step out of the vehicle. Don't argue with me.
You have no legal basis for this stop.
The dashboard camera in the patrol car captured everything. Every word, every gesture, every constitutional violation that would cost the city of Houston $15.7 million and destroy multiple careers. Officer Marcus Henley had no idea that the black woman sitting in the Mercedes outside the federal courthouse wasn't just another citizen he could intimidate. She was Judge Patricia Whitmore, a federal judge from Texas with 23 years on the bench, a former prosecutor who had put corrupt cops in prison, and someone who knew the law better than he ever would. What happened next would expose a pattern of misconduct spanning 7 years, lead to criminal charges against 3 officers, and prove that a badge doesn't make you untouchable when you violate someone's civil rights on camera. Patricia Whitmore didn't look like what most people expected a federal judge to look like. At 56 years old, she was a black woman who grew up in Houston's 5th Ward, one of the city's historically black neighborhoods. Her father had been a mechanic. Her mother cleaned houses. Patricia had worked her way through college waiting tables, then through law school on scholarships and student loans. She graduated top of her class from the University of Texas School of Law in 1989. Started as a public defender, saw how the system worked from the inside, saw how it failed people who couldn't afford good lawyers, saw how race affected every stage of the criminal justice process. She became a prosecutor in 1995, spent 8 years in the Harris County District Attorney's Office, built a reputation for being tough but fair. She went after violent criminals hard, but she also refused to pursue cases where the evidence was weak or the police work was questionable. That made her unpopular with some cops who expected prosecutors to rubber stamp everything. Patricia didn't care. She had principles and she stuck to them. In 2003, she was appointed to the federal bench by President George W. Bush. A Republican president appointing a black female Democrat raised some eyebrows, but Patricia's record spoke for itself. She was confirmed by the Senate with strong bipartisan support. For the next 20 years, she presided over cases involving everything from drug trafficking to corporate fraud to civil rights violations. She had a reputation among lawyers as brilliant, no-nonsense, and absolutely intolerant of dishonesty. If you lied in her courtroom, you were done. Didn't matter if you were a prosecutor, defense attorney, or witness. She would destroy your credibility and, if warranted, hold you in contempt. Patricia had presided over at least 15 cases involving police misconduct. She understood qualified immunity. She understood Fourth Amendment law. She understood exactly what officers could and couldn't do during stops, searches, and arrests. That knowledge was about to become very relevant. On this particular Tuesday afternoon in March, Judge Whitmore had just finished a long hearing, a complex civil rights case involving a wrongful death lawsuit against the Houston Police Department. She was exhausted. Her head hurt. She just wanted to go home. She walked out of the federal courthouse on Rusk Street in downtown Houston around 4:30 the afternoon. Her car, a black Mercedes S-Class, was parked at a meter right in front of the courthouse. Legal parking, paid meter, nothing unusual. Patricia got in her car, started the engine, and was checking her phone when she saw the patrol car pull up behind her. A Houston Police Department cruiser, lights off, just sitting there. She glanced in her rearview mirror. The officer inside was looking at her car, at her license plate, at her. Patricia had been through this before. Not often, but enough times to recognize what was happening. Driving while black in an expensive car, she sighed, put her phone down, and waited. Sure enough, the officer got out of his patrol car and approached her driver's side window. Patricia rolled down the window. The officer was white, probably in his early 40s, with a thick neck and the kind of aggressive posture she'd seen in dozens of officers over the years. the kind who thought intimidation was the same as authority. "Ma'am, can I see your license and registration?" Patricia kept her hands visible on the steering wheel. "Officer, can you tell me why you're making this stop? I'm legally parked in front of the courthouse. I need to see your license and registration. Am I being detained or am I free to go?" The officer's jaw tightened. "Ma'am, I'm not going to ask again. License and registration now." Patricia knew the law. She knew this stop was likely unlawful. She was parked legally. She wasn't operating the vehicle on a public roadway. The officer had no reasonable suspicion of criminal activity. But she also knew that arguing with cops on the street rarely ended well, especially for black people. So she made a decision. She would comply under protest, document everything, and handle it through proper legal channels. "I'm reaching for my purse now to get my wallet." She moved slowly, keeping her movements visible. She pulled out her wallet and handed the officer her driver's license. "My registration is in the glove compartment. I'm reaching for it now." The officer took her license and looked at it. Patricia Whitmore. The address matched. Everything was in order. He looked at the car, at her, back at the license. "This your vehicle?" "Yes, prove it." Patricia opened the glove compartment and pulled out the registration, handed it over. The officer studied it, taking his time. Then he looked at her again. "Step out of the vehicle." Patricia felt her anger rising but kept it controlled. "Officer, what is the legal basis for this stop? I'm parked legally. I haven't committed any traffic violations. What reasonable suspicion do you have that I'm engaged in criminal activity?" "Ma'am, I'm not going to tell you again. Step out of the vehicle. I'm going to comply. But I want to state clearly that this appears to be an unlawful detention. I'm recording this interaction on my phone." She held up her phone, showing that the voice recorder was running. The officer's expression changed slightly. Most people don't record traffic stops. Most people don't use terms like unlawful detention. Most people just comply without question. "Put the phone down and step out of the vehicle." Patricia placed the phone on the passenger seat. Screen up, still recording. She opened the door and stepped out. She was wearing a professional suit, heels, and pearls. She looked exactly like what she was, a federal judge who had just finished work. The officer looked her up and down. "Where are you coming from?" "I just left work." "Where do you work?" Patricia gestured at the building behind them. "The federal courthouse. I'm a judge." The officer actually laughed. "Yeah, okay. Sure you are. I'm a United States District Judge for the Southern District of Texas. I've been on the bench for 20 years. My chambers are on the 6th floor of that building right behind you. You can verify this very easily by walking inside and asking any security officer. You got any ID that proves that?" Patricia had left her judicial credentials in her chambers. She typically didn't carry them outside the courthouse. She only had her driver's license, which the officer was currently holding. "My credentials are in my office, but my driver's license shows my name. You can look me up, Judge Patricia Whitmore. I'm a public official. My information is publicly available." The officer wasn't buying it. He'd made a stop. He'd escalated it, and backing down now would mean admitting he'd made a mistake. So instead of verifying her identity, instead of walking 30 feet to the courthouse entrance, instead of using basic common sense, he doubled down. "Turn around and place your hands on the vehicle. I'm going to search you for weapons." This was the moment everything changed. Patricia knew the law. She knew this was an unlawful search. She knew she could refuse. But she also knew what happened to black people who refused to comply with police orders, even unlawful ones. People got hurt. People got killed. So she made a calculation. She would comply now and destroy him later through the legal system. She turned around and placed her hands on the roof of her car. The officer patted her down roughly, professionally checking for weapons. He found nothing because there was nothing to find. "What's this stop about, officer? What crime do you suspect me of committing?" "Suspicious vehicle in front of a federal building. I work in that federal building. My car is legally parked. There's nothing suspicious about it. We'll see about that. I'm going to search your vehicle." Patricia's legal mind immediately recognized what was happening. This was an unlawful stop that had escalated into an unlawful search. Every action this officer was taking was a violation of her Fourth Amendment rights. But more than that, she recognized the pattern. This wasn't about a suspicious vehicle. This was about a black woman in an expensive car. "Officer, I do not consent to a search of my vehicle. You have no probable cause. You have no reasonable suspicion. This stop is unlawful, and any search will be unlawful. Ma'am, you're being uncooperative. That gives me reasonable suspicion." Patricia almost smiled at the absurdity. "No, officer, it doesn't. Asserting my constitutional rights is not evidence of criminal activity. Illinois v. Wardlow established that clearly. You cannot use my refusal to consent as justification for reasonable suspicion." The officer's face reddened. "Are you a lawyer? I'm a federal judge. I told you that already." The officer stared at her for a long moment. His hand moved to his radio, then stopped, then moved again. He was trapped, and somewhere in his mind he knew it, but pride and anger were overriding common sense. "I'm calling my supervisor," he finally said. "Good. Please do that." The officer walked back to his patrol car. Patricia remained standing beside her, Mercedes, hands visible, posture calm. She looked up at the courthouse windows. Somewhere up there, her colleagues were probably in chambers preparing for afternoon hearings. They had no idea what was happening 6 floors below. The wait lasted 8 minutes. Patricia counted them. She watched other people walk past, entering and leaving the courthouse. A few glanced at her standing beside the patrol car. Most didn't notice anything unusual. Then a second patrol car arrived. A sergeant stepped out. He was older, probably late 40s, with the bearing of someone who'd seen enough to know when something was wrong. He spoke briefly with the first officer, then approached Patricia. "Ma'am, I'm Sergeant Morrison. Can you tell me what's happening here?" Patricia explained everything calmly. The initial stop, the officer's refusal to articulate reasonable suspicion, his demand to search her vehicle, his claim that her assertion of rights constituted reasonable suspicion. She spoke like she was delivering a ruling from the bench, clear and factual. "And you said you're a judge?" "United States District Judge Patricia Whitmore. My chambers are in that building, 6th floor. You can verify my identity in about 90 seconds by walking inside." Morrison looked at the courthouse, then at Patricia, then at his officer who was standing by the patrol car looking increasingly uncomfortable. "May I see your driver's license?" "The other officer has it." Morrison walked over and retrieved it. He studied it carefully. Then he pulled out his phone and typed something. Patricia watched him read whatever came up on his screen. His expression changed. The color drained slightly from his face. "Judge Whitmore, I apologize for this situation. You're free to go." "What about my complaint?" Patricia asked. "I want this officer's name and badge number. I want the dash cam footage. I want his body cam footage. I want incident reports. All of it." Morrison nodded slowly. "You'll have everything. I'll personally ensure it." The first officer started to speak. Morrison held up one hand, silencing him instantly. "Judge Whitmore, again, I apologize. We'll be in contact within 24 hours with all documentation you've requested." Patricia took her license back. She got in her car. She drove to her reserved parking space in the courthouse garage, where she should have been allowed to park in the first place. Then she sat in her car for 5 minutes, letting her hands shake with the adrenaline she'd been suppressing. She didn't cry. She didn't scream. She just sat there, a federal judge who'd been stopped and searched for the crime of driving while black. Then she went upstairs to her chambers and started making phone calls. The first call went to the chief judge of the Southern District of Texas. The second went to her friend who practiced civil rights law. The third went to the most prominent civil rights organization in Houston. By the end of the day, 7 people knew what had happened. By the end of the week, it would be national news. Patricia filed her lawsuit 4 days later, 31 pages, single-spaced, footnoted like a legal brief because that's what federal judges do. She named the officer individually. She named the department. She named the city. Unlawful stop, unlawful detention, unlawful search, violation of Fourth Amendment rights, violation of equal protection, racial profiling. The city attorney's office received the complaint and immediately understood they were facing something unprecedented. They weren't dealing with a regular plaintiff who might be intimidated by the legal system. They were dealing with someone who understood federal procedure better than most of their own attorneys. Someone who knew exactly what evidence to preserve, what witnesses to depose, what precedents applied. The department launched an internal investigation. They pulled the dash cam footage. They pulled the body cam footage. They pulled the officer's history. What they found made everything worse. This wasn't the first time. Over the previous 18 months, Officer Derek Chen had made 47 traffic stops. 39 of them involved black motorists. In a district where black residents made up 18% of the population, 83% of his stops were black drivers. The pattern was undeniable. Chen had been targeting black motorists systematically, and nobody had noticed because nobody was looking at the data. Patricia's case forced them to look. What they saw was damning. Chen was suspended immediately. The department tried to handle it quietly, hoping to settle before the case went public. But Patricia had already made the strategic decision to make it public. She wanted accountability, not just settlement money. She wanted systemic change. The story broke on a Tuesday morning. Federal judge files civil rights lawsuit after traffic stop outside courthouse. It spread fast. Local news picked it up first, then regional outlets, then national media. Cable news ran segments. Legal analysts weighed in. Civil rights organizations issued statements. The video footage was released as part of the court record. People could watch a federal judge calmly citing case law while being detained unlawfully. They could hear the officer's inability to articulate reasonable suspicion. They could see the moment he realized who he'd stopped and how his entire demeanor changed. The footage went viral. Within 72 hours, it had been viewed 14 million times. The comment sections filled with similar stories. Black lawyers detained. Black doctors questioned. Black professionals humiliated. The pattern was everywhere once people started looking. Officer Derek Chen was terminated 2 weeks later. The termination letter cited multiple policy violations and racial bias. His union tried to fight it. They watched the footage and told him the same thing everyone else was telling him. You're done. The evidence is too clear. But termination wasn't enough. The Department of Justice opened their own investigation into the Houston Police Department's traffic stop practices. They wanted to see if Chen's pattern was individual or institutional. The investigation took 6 months. They analyzed 3 years of traffic stop data. They reviewed thousands of incident reports. They interviewed officers and community members. Their findings were released in an 84-page report. Black motorists were stopped at rates significantly disproportionate to their population. They were searched at higher rates despite being less likely to have contraband. The disparities were statistically significant and legally indefensible. The city entered into a consent decree with the DOJ. Federal oversight for 5 years. Mandatory bias training. New accountability systems. Regular audits. Civilian oversight board with real authority. Body cameras required for all uniformed officers. The reforms were comprehensive and binding. Patricia's lawsuit moved forward despite the criminal and administrative proceedings. Discovery was extensive. Depositions lasted weeks. The city's attorneys tried every procedural maneuver available. Patricia knew them all. She'd seen them from the bench for 2 decades. Nothing worked. 8 months after filing, the case settled. The amount was never officially disclosed, but court observers familiar with the negotiations said it was $15.7 million. The city also issued a formal apology. The police chief personally apologized in a press conference. The mayor apologized. They implemented additional reforms beyond what the DOJ required. Patricia donated the entire settlement to civil rights organizations. Every dollar. She kept nothing. I don't need the money, she told reporters. I need the system to change. I need other people who don't have my position and resources to be protected from what happened to me. The case became required reading at police academies. Law schools taught it in constitutional law classes. Civil rights organizations used it in community education. One traffic stop led to a terminated career, a $15.7 million settlement, federal oversight, and reforms that changed how an entire department operated. Derek Chen never worked in law enforcement again. His termination for cause made him untouchable to other departments. Background checks flagged the racial profiling findings. He tried security work but couldn't hold positions. Employers would discover his history and let him go. He eventually moved to another state entirely, working jobs that had nothing to do with his previous career. The dashcam footage became a training tool nationwide. Police departments from Seattle to Miami used it to show officers what not to do. They'd pause at key moments. Here's where he should have recognized his mistake. Here's where he could have de-escalated. Here's the exact second he violated her rights. The footage was clinical, educational, devastating. Patricia returned to the bench. She continued hearing cases, including several involving police misconduct. Colleagues said the experience sharpened her perspective. She'd always been fair, but now she was even more attuned to the realities of racial profiling. When officers testified in her courtroom, she asked pointed questions about their stops. What specifically made the person suspicious? Why that vehicle among hundreds? What training informed your decision? Defense attorneys noticed the shift. They started requesting Judge Harrison for cases involving questionable searches. Prosecutors grew warier. Some complained privately that she'd become biased against police. Her rulings didn't support that claim. She still sided with law enforcement when the evidence justified it. She just demanded they follow the actual law instead of assuming compliance. The Houston Police Department's reforms went beyond what the consent decree required. They implemented an early warning system that tracked officer behavior patterns. If an officer's stops showed racial disparities, supervisors intervened immediately. Mandatory counseling, retraining, closer supervision. If patterns continued, termination. The system caught 17 officers in its first year. 12 were retrained successfully. 5 were terminated. Body camera requirements became universal. Every uniformed officer wore one. Every traffic stop was recorded. The footage was reviewed randomly by civilian auditors. Officers couldn't turn cameras off during encounters. Violations meant immediate suspension. The policy was strict and enforced consistently. Community oversight gained real authority. The Civilian Review Board could investigate complaints independently. They had subpoena power. They could access all department records. They could recommend discipline, and the department had to explain in writing if they didn't follow recommendations. It wasn't perfect, but it was accountability that hadn't existed before. Traffic stop data became public. Every month, the department published statistics broken down by race, neighborhood, and outcome. Journalists analyzed the numbers. Community organizations tracked trends. The transparency forced accountability. When disparities appeared, the department had to explain them. Sometimes the explanations were legitimate. Often, they weren't. Either way, the public could see. The changes weren't just policy. The culture shifted too. Officers who had worked under the old system struggled with the new expectations. Some retired early, others adapted. New recruits entered a department where bias wasn't tolerated and documentation was mandatory. The transition took years, but it happened. Patricia spoke publicly about her experience exactly once after the settlement. A legal conference invited her to discuss civil rights litigation. She accepted. The room held 300 attorneys, judges, and law professors. She spoke for 40 minutes without notes. She described the traffic stop in detail, the initial confusion, the growing realization that something was wrong, the decision to document everything, the officer's reaction when he discovered who she was, the humiliation of being detained, the anger that came later, the determination to ensure it meant something. Then she shifted focus. She talked about the women who didn't have her advantages, the ones stopped in the same circumstances who couldn't cite case law, who didn't know their rights, who complied out of fear, who were searched illegally and couldn't fight back, who were arrested on pretextual charges, who had no recourse because they lacked resources or knowledge or position. Her voice never wavered. She wasn't emotional. She was precise, analytical, devastating. She laid out the systemic nature of the problem, the data, the patterns, the way implicit bias operated, the failure of accountability systems, the courage required to challenge authority, The barriers most people faced. The room was absolutely silent. When she finished, the applause lasted 2 full minutes. Several people were crying, others looked stunned. The video of her speech was posted online. It's been viewed 4.3 million times. Law schools assign it. Civil rights organizations share it. It's become a definitive statement on racial profiling from someone who experienced it and had the knowledge to explain exactly what was wrong. Patricia received hundreds of letters after that speech. People shared their own stories. Black professionals who'd been profiled, lawyers detained, doctors questioned, teachers searched. The letters came from every state. The pattern was consistent and undeniable. She kept every letter. They filled 2 boxes in her chambers. The impact of her case extended beyond Houston. Other cities examined their own traffic stop data. What they found was uncomfortable. Disparities existed almost everywhere. Some departments implemented reforms proactively. Others waited until lawsuits forced change. Either way, Patricia's case became the catalyst. Several other federal judges came forward with their own experiences. A judge in Atlanta had been stopped 3 times in 2 years. A judge in Philadelphia had been detained outside his own courthouse. A judge in Los Angeles had been searched during a traffic stop. They'd stayed quiet before, unsure if speaking out would undermine their judicial authority. Patricia's case gave them permission to talk about it. The collective testimony from multiple federal judges was impossible to dismiss. These weren't activists or critics with agendas. These were members of the federal judiciary. Their credibility was unassailable. Their experiences forced a national conversation about racial profiling that couldn't be deflected or minimized. Congressional hearings followed. The House Judiciary Committee held sessions on police accountability. Patricia was invited to testify. She declined. She'd said what she needed to say. She'd filed her lawsuit. She'd won her case. She'd donated the settlement. She'd spoken at the conference. She'd done enough. Now she wanted to return to being a judge, not a symbol. But her case continued to reverberate. Law review articles analyzed it. Constitutional law textbooks cited it. Police training programs studied it. Civil rights curricula taught it. It became part of the legal landscape, a reference point for discussions about racial profiling, qualified immunity, and police accountability. The woman who recorded the initial traffic stop on her phone never sought attention. She provided her footage to Patricia's attorneys and testified at deposition. She refused media interviews. She just wanted to do the right thing. Her video was crucial evidence, but she didn't want recognition. She went back to her life, satisfied that she'd helped. Patricia's family supported her throughout the ordeal. Her husband attended every court appearance. Her adult children helped manage media requests. Her parents, both in their 80s, told her they were proud. Her father, who'd lived through segregation and the civil rights movement, said her fight mattered. It connected past struggles to present realities. The $15.7 million settlement was among the largest ever paid in a racial profiling case. The amount reflected both the egregiousness of Chen's conduct and Patricia's unique position. She had standing that most victims lacked. She had resources to pursue litigation. She had knowledge to articulate the violations. The settlement acknowledged all of that. Civil rights attorneys studied her legal strategy, the way she documented everything, the precision of her complaint, the strength of her discovery requests, the effectiveness of her depositions. She'd litigated the case like the federal judge she was, and it showed. Other attorneys adopted similar approaches in their own cases. What happened to Patricia Harrison wasn't unique in its occurrence. Thousands of Black Americans experienced similar treatment constantly. What made it unique was her ability to fight back effectively and her determination to make it count for something bigger than personal vindication. Her settlement donations created tangible change. The $250,000 to the NAACP Legal Defense Fund funded 3 full years of police misconduct litigation. They took cases others couldn't afford to pursue. Cases that might have died in filing fees and deposition costs instead went to trial. Verdicts followed. Precedents formed. The $500,000 to the Innocence Project expanded their wrongful conviction work. They hired 2 additional attorneys and 3 investigators. Over the next 4 years, they exonerated 11 people. 7 were black men convicted based on questionable police work. DNA evidence told different stories than the arrest reports had claimed. The National Police Accountability Project received $7 million. They used it to build a comprehensive database tracking officer misconduct across jurisdictions. The system flagged patterns invisible within single departments. Officers fired in one city for excessive force were getting hired 2 counties over. The database closed that loophole. Hiring departments could now see complete histories. But Patricia kept $8 million, not for herself, for something bigger. She established the Federal Judicial Education Fund. Its mission was direct: provide resources for sitting judges to understand the communities they served, fund ride-alongs with community organizations, support attendance at forums where judges could hear directly from people affected by their rulings, create dialogue between the bench and the public. The fund paid for judges to attend week-long immersion programs in the communities where they presided. Federal judges from Manhattan spent time in the Bronx. Judges from downtown Los Angeles visited Compton and South Central. Judges from Chicago's Loop went to the South Side, not as judges, as learners. The program was voluntary. Dozens of judges participated. They heard stories. They saw neighborhoods. They met families affected by the criminal justice system. Many said it changed how they approached sentencing, how they evaluated police testimony, how they considered the human impact of their decisions. Patricia's influence extended beyond the fund. She became more deliberate in her courtroom. When prosecutors presented police testimony, she asked pointed questions, not to undermine legitimate law enforcement, to ensure accuracy, to test credibility, to prevent the kind of assumptions that had led to her own unlawful detention. Defense attorneys noticed the shift. So did prosecutors. Patricia wasn't favoring either side. She was being more rigorous, more questioning, more aware that badges don't guarantee truth. Her courtroom became known as one where evidence mattered more than authority. Other judges followed her example. Not all, not even most, but enough to matter. Questions got sharper, standards got higher, police testimony faced more scrutiny. The culture began shifting incrementally. Officer Robert Chen never worked in law enforcement again. His termination for cause made him unhireable. He tried security work. 3 companies let him go within months. Background checks revealed the federal lawsuit and settlement. Nobody wanted the liability. He gave one interview to a local reporter 2 years after the incident. He claimed he'd been following his training, that he'd made reasonable decisions based on the information available. The reporter asked if he'd watched the Bodycam footage. Chen said he had. The reporter asked what reasonable suspicion justified the stop. Chen couldn't articulate one. The interview ended. Chen's pension was revoked under a state law allowing forfeiture when officers are terminated for constitutional violations, resulting in significant financial settlements. He challenged it, lost, appealed, lost again. The $15.7 million settlement met every threshold for forfeiture. The 5 other officers who participated in Patricia's detention faced various consequences. 2 were suspended without pay for 6 months. 1 was demoted. 1 resigned before discipline could be imposed. 1 received a written reprimand. The disparate outcomes reflected their varying levels of involvement and their disciplinary histories. The female officer who helped Patricia with her seatbelt buckle was never disciplined. Internal Affairs found she'd acted professionally throughout the encounter. She'd questioned Chen's decisions privately. She'd treated Patricia with respect. She'd done what she could within the constraints of the situation. She was actually commended for de-escalation efforts. That officer, Lieutenant Sarah Mitchell, later became a captain, then a deputy chief. She implemented training programs based on Patricia's case. She taught recruits about constitutional policing, implicit bias, and the consequences of unlawful detentions. She used the Bodycam footage in classes. She made sure every officer understood what went wrong and why. The traffic stop itself became a case study in police academies nationwide, not as an example of what to do, as a detailed breakdown of cascading failures, how a stop without reasonable suspicion led to unlawful detention, how ego prevented de-escalation, how backup officers failed to intervene, how a routine encounter became a federal case. Training officers would pause the body cam footage at key moments. What should Chen have done here? What options did the backup officers have? When should someone have called a supervisor? The footage provided teachable moments at every stage. Patricia returned to her regular caseload 6 months after the settlement. She'd taken time off during the litigation and its immediate aftermath. Now she was back. Same courtroom, same docket, same commitment to justice, but changed by the experience. Defendants noticed the difference. She asked more questions during sentencing, about backgrounds, about circumstances, about what led someone to this courtroom. She still imposed appropriate sentences. She still held people accountable, but she did it with fuller understanding of context. Prosecutors adjusted their approach in her courtroom. They knew she'd scrutinize police conduct more carefully. They prepared more thoroughly. They corroborated officer testimony with other evidence. They didn't assume she'd accept police accounts uncritically. The extra preparation improved their cases. Defense attorneys appreciated her heightened awareness. They felt they could raise Fourth Amendment issues without being dismissed. They could question police testimony without being seen as automatically adversarial. Patricia's experience gave her insight they could reference. She understood unlawful detention wasn't theoretical. The long-term impact of her case extended into areas nobody anticipated. Insurance companies changed how they underwrote police departments. Municipalities with poor accountability records faced higher premiums. Departments with strong oversight and training got better rates. Patricia's $15.7 million settlement made insurers recalculate risk. Cities started implementing reforms not just because they were right, because they were financially necessary. Insurance costs forced change where moral arguments hadn't. The economics of accountability became undeniable. Legislative reforms followed. Several states passed laws requiring independent investigations of police misconduct allegations. Others mandated public databases of officer disciplinary records. Some created certification systems allowing states to decertify officers terminated for serious violations, preventing them from working elsewhere. Patricia didn't lobby for these laws. She didn't need to. Her case provided the evidence lawmakers needed. The body cam footage showed voters what happened. The settlement amount demonstrated the cost of inadequate accountability. Legislators acted because constituents demanded it. None of this erased what happened to Patricia. She still remembered every moment of that traffic stop, the lights behind her, the approach to her window, the escalation, the handcuffs, the humiliation, the anger. Those memories didn't fade. The dash cam footage is still used in training sessions across America. You can watch a federal judge calmly citing constitutional law while being unlawfully detained. You can see the exact moment Officer Chen realized his mistake. You can witness what happens when someone knows their rights and has the resources to enforce them. Patricia Whitmore continues serving on the federal bench. She's not defined by one traffic stop. She's defined by 23 years of principled jurisprudence and a commitment to justice that one unlawful detention couldn't diminish. She turned humiliation into accountability, anger into reform, and a personal violation into systemic change that protects people who will never know her name. The $15.7 million settlement wasn't just compensation. It was a message. Badges don't grant immunity from the Constitution. Authority doesn't justify abuse. And sometimes the person you're detaining knows the law better than you do. That message reached every police department in America. Some learned it, others are still learning. Either way, Patricia made sure it couldn't be ignored. This case was brutal, but the case on the right spirals completely out of control.
In our unwavering pursuit of the truth, accountability is our highest priority. We challenge those in power by presenting undeniable facts, because the records never lie. Thank you for watching and trusting our investigations.